On behalf of the CCA, I would like to welcome you all to our Best Practices and Services webinar series. This is the third session of a 5-part series on reading your construction contract. My name is Amber Sandhu, and I'm the Regional Underwriting Officer at Travelers Surety, as well as a CCA board member. So the title of our webinar today is If I Could Turn Back Time. And what we're focusing on is considerations impacting time and schedule in your contract. Everything from discussing the importance of schedule and the implications of it to milestones, as well as how to effectively use notice provisions. I will be moderating the session today, but what you should anticipate is an open roundtable discussion amongst our panelists. We also want to hear your questions and even some of your stories. So please use the Q&A function at the bottom of the screen, and we'll be sure to leave some Q&A time for the end of the call. But first, I'd like to welcome our roundtable panelists and maybe hand it over to them to briefly introduce themselves. Starting with Geza, can I start with you?
Hello, everybody. Geza Banfi, construction lawyer, counsel at McMillan LLP, and out of their Toronto office. And I've been practicing construction law for a long time, including a stint on CCDC, which continues.
Thank you,
Frank. Okay, never.
Frank, please go ahead.
Frank Faieta. I'm with the Trisura Guarantee Insurance Company, National Vice President, National Surety Risk Management.
Thank you, Frank. And last but not least, Christina.
Hi, Christina O'Donnell. I'm with Black & McDonald. Been here for about 13 years, and I sit on the board of CCA, and I'm a CCDC member as well.
Thank you, Christina, Geza, and Frank. Frank, I think with our first topic, I just want to maybe start with you. There are typically two contracting parties in a construction contract, the owner and the contractor. Can you start us off by sharing why schedule matters for an owner, and then maybe switching hats on why it matters for the contractor?
Sure. Let's get rid of the obvious. First of all, time is money. Everybody knows this, right? For an owner, though, on a construction contract, schedule is obviously important because the owner may have a planned revenue stream coming when the project is completed that might be affected by an extension to the schedule, or alternatively, there may be alternative accommodations required if it's a building, for example, and there are tenants that are planning to move as of a certain date, and those tenants can't move. It could be an old folks home. It could be many different things that require some significant disruption for the owner if the schedule is extended. But on the contractor side, I don't think I have to tell anybody here how severe contractual extensions and delays can be to a schedule, right? The duration of work all of a sudden extends. There could be lost opportunity on other contracts. It could affect all of the subcontractors on the job. They may have, subcontractors may have commitments on other jobs that they need to honor, which means you might lose subcontractors depending on how long the scheduled delay is. So in my mind, at least, for a contractor, the impact of schedule issues can be multidimensional, whereas it's more unidimensional for an owner. Job's not finished, and then the damages kind of run from that. For a contractor, what's the real cost of a schedule delay? I'm talking real costs. I mean, the best under a contract I think you can hope for is to recover your out-of-pockets, right? Whatever you're spending, cash, you can demonstrate that as a cost, and usually as a maximum, that's what you get back. But is that what it really costs? I mean, isn't there more to a contractor that we're talking about here? Administrative issues, management distraction, reputational disruption, arguments on site, all of this kind of add up. They stack on to the impact of a schedule delay. So the message here is you need to make sure you can go out and get your money. Whatever money you can get out of some sort of a schedule extension or schedule delay that's not your fault, you need to be able to figure out how to go get it. You need to go get it. And those rules happen to be inside the contract, and you need to know what those rules are. Other people on the panel, any comments? Anything to add?
Yeah, just a quick comment from me. as from a subcontractor perspective, it kind of gets even more interesting how the schedule gets flowed down to the subs. Things in schedule could be changing either through owner requirements. It could be changing because the general contractor has slippage either through their own issues or through their other subs. It's just so important at the subcontractor level to keep an eye on that schedule and see in real time how your own critical path is getting affected, and to provide early notice so that there's no surprises down the road. Because rightfully so, you know, a GC needs and owner needs to know what slippages are, like what effects it's causing in terms of time and money that it's costing, and to get the opportunity to mitigate those impacts to the extent possible.
Yeah, all good comments, and I agree with you guys completely. Excuse me, from the point of view of a construction claims person and a contracts person, I look at schedule as on the high risk side of contracting. The possibility or the probability of delay is fairly high in many, maybe most projects, and it comes from a variety of sources, and it's been touched upon already. It starts with the schedule itself, which may be completely unrealistic, but yet if you know, and that lack of realism can emanate from naivete on the part of the owner, or it's the owner's consultant, or just a bad case of optimism bias. But then that problem is compounded by the optimism bias of the contractor, who may recognize that the schedule is unrealistic, but sign on to it anyway, in the expectation that, well, everything will go right and we don't have to worry, you know, we don't have to worry about problems. That's a recipe for a very stressful project. Other problems, everybody in the chain is potentially at fault for a schedule delay. You can have delays by owners and their consultants in giving approvals and feedback where required. You could have failures of performance by the GC in its coordination of the work, for example. You can have failures of performance by the trades and suppliers. And then you can have external factors that impact the schedule, things like weather, pandemics, and 1,000 other things. So it is a high risk part of contracting. From the point of view of the focus of these webinars, which is the contract, there are two things that need to be focused on, and that is two questions that need to be asked as you look at the contracts. First, how does the schedule get adjusted? Where's the mechanism to adjust a schedule, and under what circumstances? That's very important. And secondly, what are the consequences for a failure to meet schedule? What are the damages? Are there limits on the damages, and so on? We'll be talking about all of that as we go.
Thank you, Geza. And I think as you work a lot with owners, I think one of the considerations, particularly as we look at the news lately, it's the political risk of delays. And I think that's certainly an owner risk, the political risk of delays, but also the treasury risk of delays. And if that money will be in the coffers still if we go into another budget season. So certainly a lot to kind of think about from the owner and contractor perspective on why schedule matters. I think the next topic we have is milestone dates. And Christina, I think our next topic on milestone dates is particularly relevant. I think for you're on the CCDC committee, and there's a new concept that was introduced in the recent CCDC contracts called Ready-for-Takeover. Can you share some background on the term and maybe lead us into the discussion on milestones?
Sure. So as most of you are probably aware, the last version, the 2020 version of the CCDC 2, came with a new concept, which was this Ready-for-Takeover concept. And previously, not just holdback, not just the payment of holdback, but the transfer of project risk was tied to the legislative definition of substantial completion. But the Ready-for-Takeover concept came into play because it seemed that it wasn't necessarily the right time in the project to change the transfer of risk. And by transfer of risk, I mean, who's insuring the project? Who's responsible for site security of the project? When does the warranty period start? So the CCDC2 created this new definition of ready for takeover, which is one of the most important milestones, if not the most important milestone in the CCDC2. And it was to try to have a more fair risk transfer mechanism, because it didn't seem appropriate that care, custody, and control and the start of warranty would always align with substantial completion. So this ready for takeover was created, and it generally is fulfilled once a number of criteria is fulfilled. So the first was always there, and that's substantial performance of the contract. The next ones are a little different, because before you could have substantial performance, and you could still have substantial performance without fulfilling the next list of criteria. But this next list of criteria is necessary to get ready for takeover, which does things like changes insurance risk and starts the warranty. So the next items are obtaining the occupancy permit, doing the final site cleanup, providing any O&M manuals that are reasonably necessary for immediate operations, preparing, not preparing, but sending over any as-built that are available to date, completing testing and commissioning to the extent that it's required for immediate occupancy, providing a facility with secure access. So if it's a building, you need to have locks on the door, for example. And if training is required under the contract, it doesn't need to be completed, but you have to have scheduled the training sessions with the owner. Now there's some sort of carve-outs to this. So if any of these conditions can't be met for reasons that are beyond the reasonable control of the contractor. So the example that jumps to my mind is if we've done everything properly, we've applied for an occupancy permit, we've followed up on the occupancy permit, but there's some sort of labor shortage or strike, and we're not getting the occupancy permit for reasons outside of our control, then the contract provides that ready for takeover will be obtained anyways. Another important exception, and it's not a full exception, but if the owner decides that the project is not ready for takeover yet, but the owner decides that part of the building is ready for their use and the owner wants to take possession of all or part of the work before ready for takeover. So first off, the CCDC2 provides that both the contractor and the owner has to agree that that part of the project can be occupied. And if that happens, then with respect to that portion of the work, care, custody, and control passes to the owner, and the warranty for that part of the work starts upon possession. So where does this leave substantial performance? So it's still there. It's not something that you can take away by contract. It's a legislative requirement. Each jurisdiction has percentages of each payment that needs to be held back and put into trust upon a certain amount of completion of the project. So that's still there, but rather than transferring warranty and care, custody, and control, it's just the way the legislation intended it now, and it's a mechanism for the release of the holdback. So as mentioned, just previously, warranties now start at the earlier of ready for takeover or when the owner actually uses that portion of the project. Warranty could still line up with substantial completion, but it could also be sooner if the owner starts using the work before then. It could also be later if a contractor has met the definition of substantial completion, but the building's not otherwise ready for use. The contractor hasn't done their final cleaning or put locks on the door, or the occupancy permit's not in. things of that nature could delay the start of the warranty period. So how does this all affect interim and final completion dates? Holdback, it's still released under the legislation. It's released at substantial completion. If ready for takeover is issued before all conditions are met, the contractor would have, I guess, some sort of interim completion, and the contractor still has an obligation to diligently complete the project and work towards final completion. Warranty essentially starts upon use or when it is ready to be used. And final completion is still when the project is finally complete, and that's what triggers the final payment. That's all I have, Amber.
Thank you, Christina. That was very thorough. Frank, Geza, do you have anything you may want to add to that one before the next topic?
Well, I guess so. What we're talking about is, whereas before contracts had in there substantial completion as kind of a critical milestone where, you know, the message to the contractor was, you're pretty close to being done here. So we're going to start wrapping things up. And that triggered other things as well, just in layman's terms. But now ready for takeover, the concept is basically extended the point at which that might happen to later in the project, where substantial completion is part of ready for takeover. Now there are certain other elements that also have to be dealt with or ticked off on the list before you get to the point where a contractor can feel like, hey, I'm just about done on this, and warranties can commence and that sort of thing. So it's really, in my view, it kind of extends the time that the contractor is involved in a contract, if I'm interpreting that correctly, Geza.
Yeah, you are. And I would just reinforce one of the points that Christina made about warranty periods and the importance, excuse me, of reviewing the contract carefully to confirm when it is that your warranty period starts. And, you know, this is particularly important in cases where, for example, you have early occupancy by the owner, which is now permitted under the new CCDC 2 and other contracts. And you are, let's say, in the mechanical trade contractor who's supplying the HVAC system. And the important thing is to be aware of when the warranty on your system starts. Does it start on the date that your system is commissioned? Does it start on the date of ready for takeover? And there could be quite a spread between those two dates, with the result that you, as the mechanical trade contractor in that example, may find yourself effectively giving an extended warranty without getting paid for that, while the owner interim occupies the premises and your system is running for, say, 6 months before ready for takeover of the entire facility is achieved. So, you know, there's nothing wrong with that as long as you are aware of that and that you've appropriately priced what is effectively an extended warranty. So that's the point here. Check the contract and confirm when the warranty starts and what is the trigger date for that event. And that's all I have to say on this.
If I could just jump in quickly again, I agree with those comments, but and Gaze is absolutely right. When you're dealing with non-CCDC contracts, or you know, not a CCDC 2, and you don't have that ready for takeover concept, you do have to be careful about when the warranty starts. But just to emphasize, in the CCDC 2, that is that situation where part of the building is occupied and the HVAC system's on, the CCDC addresses that, in my view, in a very favorable and favorable manner to the contractor, but also a very fair manner. If it's being used, the warranty has to start. And what's nice about this new CCDC 2 is that it calls out that situation where the owner starts using part of the project and our work is being used, but in the old days, you hadn't hit substantial performance, so the warranty hasn't started yet. Now, the CCDC2 says, if you're going to start using our work before you've hit the standard milestone to start your warranty, it's going to start anyways. You can't use it and say it's not ready to be used, so the warranty hasn't started yet. Circling back to Frank's point, while sometimes and often perhaps the warranty period may start a little later than with the substantial performance milestone of the old CCDC document, it can also work to contractors' favor, in a contractor's favor, and start for part of an occupied piece of work when it's actually being used.
Christina. So our next topic is delay damages. Geza, maybe we'll start with you, but there's often costs associated with not adhering to a schedule. We spoke about the cost to a contractor, and often you'll see damages, or these damage provisions in the contract. Can you speak to what a delay damage is and the types of damages that contractors may see?
Well, there are damages that both owners and contractors may see, and Frank alluded to some of them in the introduction to the webinar. All kinds of things. From an owner's perspective, for example, it's the cost of extending a lease or the cost of getting alternate accommodation, to accommodate their office while the delayed office is completed. From the contractor's perspective, it's all kinds of costs: extended general conditions, extended insurance and bonding costs, claims from their subs who are flowing up, their own delay, claims against the contractor, and so on and so on. There are, in principle, there are two ways of dealing with delay damages. The first is to simply be silent about the quantification of those damages in the contract and have the matter assessed at law. By that I mean, in the case of, say, an owner is delayed, the owner will sue the contractor saying, I've been delayed, and here are my damages, and the contractor responds, and the thing goes through the process of resolving it. The other way of of dealing with a delay is liquidated damages, a liquidated damages clause, LDs. And these are not uncommon, and they are typically found in contracts between owners and contractors, and stipulate that in the event of a delay for which the owner is not responsible, the contractor has to pay the owner a stipulated amount per day of delay. The stipulated amount could range from $500 to 5 or 6 figures, depending upon the job. And legally, the idea behind LDs is that it is a true liquidated damages clause is intended as what's called in the cases a genuine pre-estimate of the damage that an owner might suffer in the event of a delay. So there has to be some thought given to what the loss that an owner might suffer in the event of a delay would cost. And it should be a reasonable figure. If it is not, then that clause risks a finding that it is not a true enforceable liquidated damages clause, but rather is a penalty. And a penalty at law is unenforceable. You can't penalize someone for not complying with your contract. The penalty being an added penalty or an added financial burden that the contract breaker must pay. That's not enforceable at law. And so there are instances where liquidated damages clauses have been struck because they have been found not to actually constitute a genuine pre-estimate of anyone's loss. What they were really intended to do, so finds the court, is to be a stick over the contractor's head, all out of proportion to the actual loss that the owner might suffer, and or just another source of unjustified cash recovery by an owner who's looking to capitalize on a delay. That's no good. From the point of view of the contractor, I've been told by more than one contractor that liquidated damages, assuming that they're rational and reasonable, are actually not a bad thing, because it allows the contractor, when he's bidding the job, to quantify the risk. And so they do serve a valuable function to the contractor in terms of pricing the job. They also allow the contractor to use the liquidated damages as a shall we say, a lever over the trade contractor to get them to perform in a timely way, reminding them that if there's a delay for which the trade contractor is responsible, the GC will be back charging. So contractors, it's not necessarily a bad thing from the point of view of the contracting community. The keys about LDs are that they are reasonable, and when you're reviewing a draft contract, they will jump out. You know, that number will jump out at you, so you have to make an assessment. Is this a rational number on a per day, a per day of delay for which I'm responsible, or is it completely ridiculous? The second key when reviewing an LD clause is the liquidated damage, are the liquidated damages the sole and exclusive remedy available to the owner in the event of a delay? That's the idea behind a liquidated damages clause, but occasionally we see clauses that say the opposite. They say, in effect, if there's a delay, the contractor pays $5,000 a day, and this is not the owner's sole and exclusive remedy in the event of a delay. Well, that is a small consolation or no consolation at all to a contractor, and that is the kind of clause that should be pushed back on. The intent of the LD is to quantify the delay risk, and that's it. So that's all I want to say about LDs. Anybody want to jump in on LDs before we go down the rest of the slide?
Geza, so just on LDs, it's very helpful to understand how LDs, like an LD amount that's considered to be unreasonable, would lead to the provision being unenforceable. But that doesn't mean that there's no recovery by the owner for damages. That's correct. For extended duration, right? There'll be whatever reasonable amount somebody decides it should be instead of that number, right?
That's correct. It is said that if an LD clause is held to be unenforceable, then damages are said to be at large, which means that, well, they are whatever the owner can prove. Right. So, it's not a get out of jail free card for the contractor, but it does defeat the purpose of the LD. Remembering that the purpose of the LD, in addition to helping the contractor quantify his risk, is to save the parties the time, trouble, uncertainty, and expense inherent in proving actual damage. They don't have to, assuming that the LD clause is valid. They don't have to. They just say, there's the LD clause. So I, as the suffering owner, don't have to go on to prove my actual losses. They may be greater, they may be less. It doesn't matter. The LD clause governs. So that's the intent. It's to short circuit and eliminate a big source of potential controversy.
Right. So a contractor reviewing a contract, or a subcontractor reviewing the prime contract, when that contractor is bidding a job and sees a number for liquidated damages that seems ridiculous, right? This is crazy. This number will never be enforceable. What do you think should be the reaction in terms of pricing?
If you have if you have an opportunity to negotiate, then take that opportunity and negotiate that number down to something more manageable. If you don't have an opportunity to negotiate, and it's a take it or leave it situation, then you as the contractor have an unpleasant choice, don't you? The choice is either not bid, because the exposure on this particular job, having regard to the schedule that you're given and so on, is just unrealistic. And you're not prepared to assume that risk. Or assume the risk. Sorry, assume the contract with the liquidated damages clause, knowing that two potentially unpleasant things may happen to you. The first is that if the liquidated damages clause is actually enforced, then you, the contractor, will then be put in the position of coming to court and asking the court to rule that the LD clause is unenforceable.
Right.
And that can be an uphill battle. The second unpleasant thing is that a very onerous LD clause will naturally drive the behavior of the construction team, not necessarily in a good direction. People will be very conscious about the magnitude of that liquidated damages exposure. There will be lots of, the risk of finger pointing down among the construction team and between the construction team and the owner is going to be elevated. There will be a temptation to cut corners, and that may have other implications to quality and especially to safety. I've been told by more than one contractor that he absolutely refuses to speed up his work if it means a threat to the safety of his people. So it's not a happy situation where you're dealing, especially where you're dealing with liquidated damages that are ridiculous, onerous. So the better option is to, if you're going to use LDs, the better option is to stipulate LDs that make some commercial sense that people can accept. So let's go on to the slide. I'm looking at the time here. I'll go quickly on the rest of the slide. Consequential damages. It is now there are broadly speaking, there are two kinds of damages: direct damages and everything else. Direct damages are the damages that directly and immediately flow from a breach. So, for example, if a contractor abandons the job halfway through, the direct damages suffered by the owner will be the increased costs that the owner will have to pay to the replacement contractor to finish. Consequential damages are a species of indirect damage, and as the term implies, they are damages that are suffered in consequence of a failure to perform. And we're talking about things like loss of profit, loss of business opportunity, loss of use, loss of reputation, all kinds of things. And it is not at all unusual now to find in contracts a clause whereby the parties waive their liability for consequential damages against one another. And that's a good thing. It restricts the potential field of battle to direct damages only, and nobody has to worry about dealing with these other losses and arguing about them for weeks. So look for a clause in a contract that waives consequential losses. And if the waiver of consequential losses goes only one way and not your way, then an appropriate pushback would be, listen, let's make this mutual. Let's both of us agree that we're not going to engage with one another about consequential damages if we have a problem. We're only going to engage with one another about the direct damages that we suffer. So that's what to look for. Concurrent delay is generally not covered in contracts. Concurrent delay means a delay that's caused by both of the parties independently, but the delay event occurs at the same time. So it's a concurrent delay. The whole subject of concurrent delay is complex and a little unsettled in the law as to how you deal with it. I'm not going to go on about that. For contract review purposes, the important thing is that whatever liability for delay clause is in the contract, that it expressly limit the liability for a delay for which the defaulting party, the contractor, is responsible. So that kind of language should be in there so that the contractor, in my example, doesn't unwittingly pick up an obligation to cover any delay, no matter who caused it. That's not reasonable. So look for language that restricts the obligation to pay for delay to stuff that's your fault. Finally, limits and caps on delay, again, quite common and a good idea. And these are clauses that and you should look for these in your contracts. These are clauses that put, as the term implies, put some sort of a limit or a cap on the maximum liability for delay, or indeed for any breach of the contract in some clauses. The benefit to, again, as between an owner and a contractor, the benefit to the contractor is obvious. It puts a limit on his, he knows what his total, what his potential downside exposure is, even in an Armageddon scenario. The benefit to the owner is that the owner presumptively gets a better price from a contractor who doesn't have to price unlimited liability, which the contractor will. So limits or caps on delay damages are very common, and you should look for them. That's all I have to say on delay.
Thank you, Geza. It's really important, right? Make sure they're reasonable, make sure they're quantifiable, and take a look at the exclusions. Make sure that the LDs or the limits are kind of within the bounds of what's normal and reasonable for the scope of the contractor's work under the contract. Very good. Frank, I think we're moving on to the next topic, which is on notice provisions.
Right.
Can you lead this conversation? What are notice provisions in a contract and how can they be used effectively?
Well, so let me just, to talk about notice provisions, here's what I want to tell you about that. I want to share a quick story about one of the CCA events that I attended. I ended up sitting at a dinner table with a contractor and a couple of members of that contractor's team. We had a great time. He loved the joke. He loved to laugh. We had a wonderful time at the table. But when the conversation came around a job update or one of the contracts, he became very serious. His face completely changed, and he had this sort of severe, laser-focused look in his face. And he would, he would talk about, for example, something had happened on a job, and he would point with his index finger straight at the ground, and he would say, "That's money." And that stuck with me because that is, when you look at a contractor, you think, boy, that guy he's laser focused on the important thing here, and that's money. Get the job done, but it's money, and he identifies what's money for. So when you think about a construction contract, really, the project is a machine to build something, right? It's a complex machine with lots of moving parts, like a car. So, for example, I'm driving in my car. The car has warning lights in it, right? Something happens with the engine, or a light burns out or something. I get little warnings on my dashboard. So I'm driving along, and the engine light comes on, and what do I think? What's my reaction? Say it with me. That's money, right? The engine light comes on, and I'm thinking, boy, that's going to cost me something. But I appreciate it because at least I know something's going wrong with the engine. I can go fix it so that it doesn't cost me a ton more. And that's what we're talking about, these notice provisions. It's not just, boy, in the contract, I got to write this letter, and I got to write it at a certain date, and if I don't, something's going to happen. Well, those notice provisions are built in partly for many reasons, but partly to give a distant early warning to all the parties to say, hey, there's a problem here in this aspect of the contract. It's going long, or it's costing more for some reason. That's perhaps not the fault of the contractor. And we're just letting everybody know, maybe there's a way to mitigate. Maybe there's something that can be done to try to keep whatever the impacts of that problem are to a minimum. But everybody needs to know about it. So that's why these letters need to be written. That's why they're in the contract. And they're very specific. They say you have a certain number of days after the point at which you realize something's going wrong in the contract to write a letter. Otherwise, if you're looking for money, you're not going to get it, right? So these notice provisions are very important to understand. They're very important to comply with because, if you don't comply with them and you're looking for money, I think the first reaction you're going to get at least is, sorry, you didn't comply with the contract. So you need to be out there with the notices, and they're not, nobody likes to get a notice about an extra, right? It's just not pleasant. But often, you need to think about it as not just the party on the other end of the notice for you. It's the entire ecosystem of people, the company, the project that has to be informed of this as well, that that needs to know about it. So whereas there might be a bit of a relationship issue, just they're gonna get mad at me if they get another notice from me. No, it's necessary. So it's unfortunate somebody might be frustrated or upset with me, like me with the engine light, but listen, I still need it. I still need that notification. So, and I don't know what I would do without those notifications, and they're an essential part of the contract. So don't hesitate to give the kind of notices that are required under the contract. Don't be thinking, hey, my relationship's going to be affected. It helps to give other parties a chance to prep or mitigate whatever issues might be coming up. And also, it's a way for you to set you up to go and get your money, the money you're entitled to. And that's really for notices. Read the contract, figure out what the triggers are, write them down, make a note, and when they come up, if something comes up, write that letter. It's a letter, could be 10 letters, could be 20 letters, doesn't matter. Do it, get your money.
Thank you, Frank. That's a great story. Christina, I know you had a really great one as well. Do you mind sharing with the group?
Sure. And I agree with everything Frank said. Timely notice is important. Knowing what your notice provisions are in the contract is very important. But just a little a story on an absurd notice provision that we encountered, and you see it from time to time, and it usually gets, sometimes the time frames get more and more restrictive the further down the chain you are in a project, because of other parties' notice requirements as well. But this one example I'm just going to share is we were a subcontractor on a large infrastructure project. The subcontract was reviewed and negotiated during the proposal phase. And during that time period before we had submitted final pricing, a very restrictive notice clause was identified. It had us providing written notice of any event that may cause an impact to the project within 24 hours. The triggering point was not knowledge that there would be delay or increased costs, but 24 hours of the event occurring. And it was drafted in a way where compliance was an express condition precedent to payment. And we were acknowledging that our failure to strictly abide by this notice clause was a waiver of any claim we might have. So we tried to negotiate something more reasonable, but the GC team wouldn't budge in this case. It was, as I mentioned, a large infrastructure project, so it's complicated. There's lots of parties on site. We knew that there would be many potential impacts to the project, and that these potential impacts, if you have to notify the GC of them before you even know that you've been negatively impacted, that we'd basically be sending out a written notice on a daily basis. So after realizing that we were stuck with this notice provision, we basically had to budget in project coordinator time, a significant amount of time of their day to be spent putting in daily delay letters to the GC. These letters came out pretty much daily throughout the project. And a few months into the project, the GC team asked us to stop with the notices. It was annoying and it was causing them too much time to respond. We kind of laughed a little and said, sure, we will we'll change that. We're happy to change that. We wanted to change that from the beginning. Let's get our contract revised. And the GC did not want the contract changed, so they continued receiving the letters. And it's a pain. It kind of goes too far in what's useful to the project, but we were given these provisions to work with, so we didn't want to compromise our ability to claim later if we needed to.
Thank you, Christina. Geza, before we move on to other matters, do you have any kind of final thoughts on notice provisions for the group?
Well, it's a great story that Christina just mentioned, and I've heard this one before. Be careful what you wish for. If you stipulate a notice period that's stupidly short for whatever reason, a day or 2 days, and you find yourself with a competent counterparty who's read the contract, well, you're going to get a lot of notices, and your administration time is going to go through the roof. And so, when you're reviewing the contract, look for that notice period, and just assess the time. And does it make sense? Is it crazy short? Can you live with it? And so on. Also, look for the trigger. And the trigger in Christina's case, and I've seen this before, is that the time starts when the event occurs, not when you the contractor are aware of it, but it's when the delay causing event occurs. That may effectively be a notice provision that it is impossible to comply with, because you may not know that the event has occurred until the time has passed. So you gotta read the contract, the notice provisions, carefully from that point of view. Only the last point, Frank, with your permission, I'm going to steal your metaphor about the engine warning light, because I think that's just perfect as to the basis, the reason for these notice provisions. It is an engine warning light. Nobody likes the warning light to go off, but boy, you're sure grateful that it did, because it saved you a lot more money. And that's the point of a notice provision. So, our counsel to you is reframe all of this. If you're hesitant about giving notices because you're worried about the relationship, or you're worried about pissing off the owner, or whatever, no, tell the owner, listen, it's an engine warning light. That's part of our job, and here it is. Beautiful. I'm going to keep that metaphor, Frank, if I can.
No problem. Go ahead.
All right.
Yeah.
Thank you, Geza.
Okay.
This is a deceptively succinct slide, but 2 concepts you will find in any construction contract. Geza, can you start us off by demystifying time is of the essence, and sharing sharing more about force majeure in a contract?
All right. Well, let's start with force majeure. Force majeure means overwhelming force. That's the literal translation of the term. It's a French term. And the idea behind a force majeure clause is that if there is some event or circumstance out there that neither party is responsible for, that's important, and that is unforeseen, that's also important, then the parties can agree in a force majeure type of clause to effectively deal with the risk of that event occurring. It's like Nassim Taleb, the intellectual who invented the term. It's a black swan event. Doesn't happen often, but when it does, it's a problem. We're talking about COVID-19, earthquakes, wars, riots, insurrections, that kind of, or abnormally adverse weather, for that matter. So that's the idea. Force majeure clauses are common. But here's what to look for. Read the clause carefully, because the force majeure event will be found, whether or not the force majeure event kicks in depends upon whether or not it's covered by the clause. If it's not covered by the clause, you cannot rely upon force majeure. The standard classical allocation of a force majeure risk is to effectively split the risk. And CCDC does this. Interestingly, CCDC never uses the term force majeure, although it does contain a force majeure clause. It's GC, I think it's 6.5.4 or something, which says that, in so many words, where you have a war, abnormally adverse weather, and a bunch of other listed things, then the contractor gets time. There's an extension for the duration of the event, but no money. And that's the splitting of the risk. Each side bears the economic consequences of this event for which neither is responsible, but there is an extension to the time. So look for that, and make sure that the list of force majeure events, undertake an exercise of the imagination. Think about the potential force majeure events that might impact you and see if they're covered by that. The other thing from a contractor's point of view, and COVID-19 brought this to the fore, is the classical allocation of a force majeure risk, while it works or is generally accepted, in a scenario where you have one owner contracting with one contractor who's doing one job for that owner, well, restricted to that one project, it's an acceptable allocation of risk. But if you're a contractor contracting, if you're a medium-sized contractor, say contracting with 6 separate owners at any one time, or if you're a large contractor contracting with dozens of different owners at any one time, then the I get time, but I don't get money allocation of risk doesn't really work for you, right? It can bankrupt you. So what that has given rise to, this COVID-19 brought this to the fore. So what that's given rise to are other provisions in contracts now that deal with risks like this, including pandemic, including material price escalations and so on. So I just alert you to that as you review contracts, to think about that and consider whether a force majeure type of risk should be allocated in the classical way where you get time but no money, or whether you should bargain for some form of relief on the principle that your bankruptcy as a contractor is not going to do this owner any good at all. So that's why the owner should be prepared to offer some sort of a compromise compensation in the event of a force majeure in certain cases. That's all I wanted to say about force majeure. Any comments before I go to time of the essence? No.
You're okay.
All right. Let me just finish up with time of the essence. I smile because this is an amusing clause. It's a great example of a clause that is perfectly appropriate in one kind of contract, but completely inappropriate in a construction contract, and yet has migrated into construction contracts in an unthinking, dumb way. Time of the essence is typically found in spot transactions, i.e. contracts that are meant to be performed at one moment in time, such as an agreement of purchase and sale of real estate. There's a closing date and time is of the essence, and that deal closes on that closing date. And if there's any reason why either the vendor or the purchaser cannot come up with that which they need to come up with on that closing date, then the innocent party is entitled to treat the contract as broken and to sue for damages. So it makes sense in a spot transaction. But a construction contract is not a spot transaction. It's a relational contract extending over a long period of time. And the thing about time of the essence legally is that it is what's called a condition. And the legal significance of a condition is that the breach of a condition entitles the innocent party to treat the contract as at an end and sue the other party for their loss, breach of condition. So again, that makes sense in an agreement of purchase and sale or other spot transaction. But in a construction contract where you have many deadlines, many time periods, in CCDC2, for example, there are something like 32 of them. If you go through CCDC2 carefully, you'll find about 32 deadlines for people to do one thing or another. And if you were to take 1,000 owners and 1,000 contractors and ask them, do you really mean that if there is a failure to comply with any one of those 32 deadlines, that the other side is entitled to terminate the contract and then sue for damages? Well, I dare say that 990 of them would say, no, we don't mean that at all. We're not going to terminate the contract. At worst, we're going to sue for whatever delay or whatever consequences there are of a failure to meet the deadline. But we're not going to terminate the contract. Damn it, we wanted the job built. And the other 10, I suspect you wouldn't do business with because you'd question their sanity. So you see time of the essence every now and then in construction contracts. They, in my view, are probably not worth the ink spilled to write them for the reasons that I've just expressed. And the second reason they're not worth the ink spilled to write them is because they are almost invariably waived by the conduct of the parties. And you can waive conditions by your conduct. And it is not at all uncommon for people in a construction contract to not necessarily comply with each and every deadline for each and every step. There's give and there's take. Well, now you have waiver by conduct, so the time of the essence clause has disappeared. So that's my rant about time of the essence. I think what people mean when they try to insert it into construction contracts isn't that it's a legal condition. All they're saying is, well, time is really, really, really important to us. Well, okay. And that may have a psychological significance, but probably no legal significance at all. So
Thank you, Geza. And it wouldn't be, it'd be ironic if we actually concluded the time section on time, but I'm going to try to get everyone out as quickly as possible.
All right.
We have one slide, and I hate to do it to you, Christina, but can you wrap this up in a minute?
Yeah, I'll try. I won't say much on this. I think it's pretty self-explanatory in a way. When you're a subcontractor on a job, almost every time, it's going to incorporate the terms and conditions of the prime contract. So first and foremost, make sure you get a copy of that prime contract so that you know what's being flowed down to you. Take a look at the order of priority provision. If there's a conflict or an inconsistency, does the prime contract govern or does the subcontract govern? You need to know that so that you actually understand what your subcontract says and what the risks are. Take a look at it. How does it work? The prime contract, how does that affect the milestones and notice provisions that you thought you agreed to in your subcontract? It could affect it in a way you haven't contemplated. And that's really it. Just make sure you get that prime contract and understand how it works with the subcontract. If you think the subcontract is the full contractual picture, you only know half the story without getting the prime contract, provided that it's been flowed down to you, which it almost always is.
Thank you, Christina, and thank you, Frank and Geza, as well, for joining us, and the participants for joining us today as well. Our next webinar in the series will be May 15th, Risky Business. It's all things insurance, contract, security, indemnification. So please don't miss it. Thank you for joining us.
There's going to be a poll, I think. A poll.
There won't be.
Right there.
Oh, popped up. If you could hang on for a minute, please do the poll. And it looks like we got a very good response to this poll. So looking forward to see you guys in a couple of weeks. Thank you.
Thank you all.
Thank you.
All right. Bye-bye all.